Hello and a very good afternoon to all of you in LawyerGenics presents the webinar series edition 3. So before we start, yesterday was Teachers Day. So on behalf of LawyerGenics, we wish all the teachers a very happy Teachers Day. So today we have a very interesting topic for all of you. Which is basically on narco-analysis on constitutional law and human rights. So today we have with us a very eminent personality with us. So we have with us Miss Koyel Roy talking about ma'am. Ma'am is currently an associate professor at Amity University, Kolkata. She has done specialization in corporate law, intellectual property, criminal law, cyber law, human rights and international law. Ma'am is presently pursuing PhD from University of Burdwan. Ma'am was an ex-professor at Alliance University, Bangalore, ex-professor at Christ University, Bangalore, and Techno India University, Kolkata. Ma'am has 6 years of experience in the field of academics, and she was before joining the academic, she was there in the High Court, and she used to practice there. So before we begin with the webinar, so I would like to speak a few words on what is the entire platform LawyerGenics all about. So we are an extremely an internet online platform. We have a group of marketing team and campus ambassadors, and we also have content writers who write very interesting topics at our websites. We provide content and help and also provide media promotion to all the students so that other students can get to know about the various law events going at our country and in the state. And also, so now, ladies and gentlemen, let's not wait for so long. And ma'am, welcome you to today's live session. Over to you, ma'am.
Good evening, everybody. So today my session is basically on the narco analysis. And it is like the need of the hour as well. And what is the basis of the narco analysis? How many types of narco analysis is there in India? Whether it is admissible or not, and what is the law basically preventing that, or which is there. All these things we'll get to know. So today, not wasting much more time, I'll start off with my presentation. So let me first share you the PPT with you so that it will be helpful for all of you to, understand that what is the basis of the narco analysis, or what is the basis of the topic for today. So this is the topic for today's, that is the concept of narco analysis in view of Indian Constitution, law and human rights. So Indian Constitution law, we'll look into what is the perspective of Indian Constitution, law and human rights, and basically the narco analysis. So before going into this, I would like to tell you that why narco analysis. Narco analysis is basically we generally find the true and the lie. So something is there between the truth and the lie, because we generally say true or we generally lie to a person. That is the test, actually, the narco analysis test, which actually from the very beginning, it takes out the truth. Now, how much or to what extent is it is valid, that is the thing that today we'll discuss. So in this first thing which I have played, I'm showing it to you. It's like all truths are easy to understand once they are discovered. The point is to discover them. And one such way to discover truth is narco analysis. So basically the narco analysis is just the way of taking out the truth from that particular thing. So it's very easy, actually. We generally, after discovering it, it's very easy to know that this was the truth. But how to discover it? That is one of the way, that is the thing that is our topic today to discuss, is narco analysis. So I just put on a very small topic, because narco analysis is not only a legal way, but also a scientific way, which as actually of a law background. Being of a law background also, it is we should know about a bit of a medical background also, because narco analysis, there are certain kind of drugs which are used actually to basically take that truth out from that particular accused person. So this is the thing which actually was developed from science, so development of law, and basically at least the lay person should understand it, and there should not be any other kind of complexity regarding the admission of the evidence in the court. So narcoanalysis is nothing but the scientific development that has been, increasingly alarming in India today. So this particular narcoanalysis, the word has been taken from the Greek word, as it's written here, narc, which means anesthesia or torpor. So basically there is an anesthesia which a particular person has to go, and the person has to there will be some questions that will be asked to that person, and the person will speak about that thing. So it will be basically on a diagnostic way and a technique which is used by certain kind of drugs, and like the mental elements of that particular person, which the person was in the conscious mind, the person was not speaking, but on that mind the person would have been speaking the truth. So this is the basic introduction of the narcoanalysis, a very small and very simple introduction which I could have stated it to you. So basically, what is narcoanalysis? So administration of narcotic drugs, substantially IV to induce subconsciousness, so that the subject is mentally incapable of inventing the falsehood that he or she may have used to conceal the guilt, and hence will tell the truth on being asked a question. So basically, whenever there is a particular, subconscious mind, generally it's like whenever we are conscious, if we are asked about something, we generally are conscious to say that particular thing, and we'll think about it twice and then tell it that what is we want. But what is the truth? Basically, that is there. We cannot actually understand what is the truth. And one more thing, this narcoanalysis is a process which is basically used in a criminal investigation. So this particular thing is investigated, whatever the things may be, it is done through the drugs, narcotic drugs, which is subcutaneously, which is induced with that particular subconsciousness of our mind. So in the consciousness and non-consciousness, there is a subconscious mind which is playing, which is there in everybody. So if we are sleeping while we are getting a drug, in that if a person is induced with that drug, the person will be subconscious, not totally unconscious, not totally conscious. It will be in subconscious state where the person will be asked certain questions, and the person will definitely give the answer to that. So to cut a long story short, narcoanalysis means making a person spill the beans. So in sense, in a very short and very nutshell, I would say that to spill the beans is nothing but the narcoanalysis. So this is the role of narcoanalysis in the medicological and investigations in civil purposes, in disputed paternity cases, insurance claims, pre-employment screenings, all these things. In these cases, civil cases or civil purposes, these are generally utilized, and in criminal cases to testify the truth in statements made offenders, criminals and suspects. So in these sort of cases, basically the role of the narcoanalysis or investigation is basically made. So in India, we will be generally looking into in India in what are the cases it has been utilized and what is the present scenario of the narcoanalysis. So not only narcoanalysis, there are other tests as well. We will be discussing about those things as well here. So the first person who has been inventing this particular thing is Dr. Robert House. So who has first performed this thing, a Texas obstetrician in the year 1922 on a couple of prisoners using the drug stropholumin. So this is a particular drug. So this particular drug was utilized, that is scopolamine. This drug was utilized by Dr. Robert House in Texas, in US actually. First, it was utilized by Dr. Robert House in the year 1922, and it was really helpful. And one more thing, person should be known about the thing, that yes, I am known about the thing. I should know about the test. What is the test going on? And the person should voluntarily give his will or her will on that particular test. So this is the way that it was conducted in the year 1922. So cases even in India, it was performed. As you can see, Arushi Talwar case in the year 2008. It is a very important case, and which actually was like, even a movie also has been, in like a movie was also, I think a movie is also there regarding Arushi Talwar. I think so. That is the name of the movie. Talwar case. I think people have known about this case even, that there was two persons, I mean the daughter, I mean Arushi, as well as the maid, even both the persons were killed, I mean murdered on the same date. So this was the thing, and there was a narco-analysis test which was actually performed on the various persons even in that particular case. Even in Ajmal Kasab case also, Kasab was also undergone with this narco-analysis test, where this was the only proof that the person have spoken the truth, and he was like Kasab is no more because he is hanged till death. So even in Nithari murder case in the year 2006, and even in Abdul Karim Telgi fake scam case in the year 2006, these things were utilized. So I'll go into these kind of cases later on. First, let me just give you about what are the drugs that are used for narco analysis. So these are the drugs that are utilized in narco analysis as ethanol, thiopenton, okay, flunitrazepam, then midazolam, then quinisidinum, benazetine, and scopolamine. So these are the drugs that are utilized. And if I am talking about thiopenton, then this is the thing how thiopenton sodium is actually utilized in the, I mean this is the way that narcoanalysis test has been utilized through the teeth. As you can see that site of the barbicutis and site of pictotrons, site of GABA, then chlorine channel, site for steroids, site for benzodiazepine. So these are the things that how these things has been utilized. These are the mechanisms of action of thiopenton sodium. So thiopenton binds the GABA clean of the channel complex. So basically the promolars and the premolars where these things has been given, the drug has been given there, and increased duration of opening the chloride channel, then GABA medicated chloride condensation, then CNS hyperpolarization, and then semi-conscious state. So like this, the person, so basically the drug will be given in the molars and premolars teeth, and thereafter the person increasing of that thing will, and there is a particular time limit. So basically it can be for 1 hour or 2, maximum 1.5 hours, not more than that, because this is also dangerous to the health of a person. So this is how the thing actually goes on. So how semi-conscious state helps. So semi-conscious state, on being asked a question, the person will be unable to manufacture the falsehood, answer all the questions properly and truthfully. So once that particular sodium or that drug has been given, then the person slowly and steadily, the person will go into semi-conscious state, and the person will ask certain questions, and the person will not be able to make up something on his own. So the person will definitely will not hide the truth, and the truth will come. So this is the way that it works. So thereafter, this is the procedure of the narco-analysis test. So as you can see that it includes all the interviews test. So how it actually goes on. The first one is the pre-test interview. So individual is informed about the whole procedure, and informed consent is taken. So the very foremost thing which I told you, that the person consent is the foremost thing. So somebody should not be forced. The person should be known about that I am going into this particular analysis test. The person should not be forcefully done. The person should not be forced that you have to do it. This should not be the thing. If the person don't want, then the person should not be taken into that particular test. So the first thing is, before going into that, there will be a pre-test interview where the consent should be taken. Next, after that, pre-narcotic state, developed as soon as 5 to 10% thiopenton is administered. So thereafter, after that, pre-narcotic test is that after that 5 to 10% of that drug should be administered in the body. Thereafter, semi-narcotic test, characterized by flushing, slurring of speech, and nystagmus, like in sense that particular state, the person will be totally subconscious in that state. So the person will be slurring the speech. It will not be clear enough, but the person will definitely try to say the truth. The person will, in that state, it's certain kind of a state where the person will don't want to say, but the automatically the person will say. So that is the state actually. So this will be the semi-narcotic state. Thereafter, after that, the post test interview. So once the individual wakes up, his memory is checked, and after that he is allowed to know what he has spoken during the interview. So this is all about the procedure. This is how it goes on, because that's what I told you, law is there, but these are the things where scientific methods are utilized. So some of the other we should know about the drugs which are actually utilized in this narco-analysis test. So that is why I told you that these are the drugs which are utilized in narco-analysis test. So basically, the thiopenton is very much utilized in India. That is why I've given you this also, that where it is given in that premolar and molar teeth, and the person will increase the opening of the chloride channel, and thereafter the person will be semi-conscious in the semi-conscious state. So this is how it goes on. But still, science never solves a problem without creating 10 more. So there are certain kind of drawbacks as well. So the drawbacks are that the drug used, that is thiopenton, has several toxic effects, hence may be deleterious for the health of the subject. So not possible to determine what the ideal dose of the thiopenton for a person would be. Sometimes it is actually very much, dangerous to a person who is going into these sort of tests. So a competent and skilled interviewer is needed, not 100% accurate. So these are the drawbacks. So definitely we'll come into the criticisms of the narco-analyst test, but we need to see through the legal background as well. So what are the laws, even what is the thing now, what Supreme Court has stated, what is the scenario now in India, all these things we need to check. So before going into the criticisms, or before going into the other way round of the other person stating, I would definitely like to come to what the Supreme Court of India says. So before going into that, I would state that Article 20, Clause 3 of the Indian Constitution, this is one. Not only that, Article 21 of the Indian Constitution, which is talking about right to life, even a right to privacy. Even there are other acts as well, like Criminal Procedure Code, Article 161. Even all these things, if you take into consideration, where it is saying that in Article 20, Clause 3, it's saying that no person accused of any offense shall be compelled to a witness against himself, in sense, right against self-incrimination. So anyhow, this particular test is going against these right against self-incrimination, where it's clearly stated that no person who is accused can be, giving the witness against himself only. So this is the way which is contradicting the test. Next, thus the Supreme Court of India has said that no individual can be forced to undergo narco analysis involuntarily. So consent is very, very essential. So consent is something, I think without consent, if something is going, that is actually offense. That is an offense. With consent, if anything has been taken or anything has been done, I don't think so that is a offense. But yes, that consent, or the person whenever consenting should be trusting that person. The person also should be taking it into good faith. The person who has been taking the consent should not deny the truth of the fact. Instant doctrine of estoppel is also involved in this particular thing. So irrespective of that, I would say that the person involuntary or forcefully should not be taken. The person himself to prove himself that I don't have any kind of, I am totally a clean sheet person, I don't have any problem in myself, I want to prove myself that I am not guilty. If a person states so, then these kind of things is okay, and these kind of things is legal, but otherwise it is not admissible in the court of law. So informed consent is an essential prerequisite for this procedure. So informed consent is basically an essential prerequisite for this particular procedure. So it is alleged that narcoanalysis test is violative of his fundamental rights under Article 20, Clause 3 of the Constitution of India 1950. It guarantees protection against self-incrimination. Even the Fifth Amendment to the US Constitution provides for the same privilege. Not only that, the rights guaranteed under Article 14, Clause 3, Subclause G of the International Covenant on Civil and Political Rights 1966 even guarantees that the narcoanalysis test is actually violative of these particular things, because where the fundamental rights of the Indian Constitution Article 20 Clause 3 is saying that if a person is guilty, the person cannot be the witness against himself only. So where the narcoanalysis test is saying that the person in semi-conscious mind is saying the truth. So is it not that it's contradicting? So that is why the Supreme Court stated that if a person is coming with his or her own will and with clear informed consent that yes, this particular thing is taken so that you will be proved guilty or you will not be proved guilty, if this is the thing, and the person on his own will comes and gives, then definitely these sort of things are taken into consideration. So it deals with the privilege. So Article 20 Clause 3, which I told you, that no person accused of any offense shall be compelled to be a witness against himself. So subjecting to the accused to undergo the test. So the investigative agencies in India consider that it is totally bluntly violative of Article 20 Clause 3. It was held to attract the Constitution. So basically the thing which we have discussed previously. So the privilege, what is against is self-incrimination, is actually enabling the maintenance of the human privacy, and which is, maintaining the standards of the criminal justice as well. So it is observing the standards of the criminal justice system and also maintaining and protecting the human privacy. So right to life and right to privacy, which is involved in that right to life. So where we say that the person is not involved to, if I am silenced, for example, I don't want to speak, is it forceful? Nobody can forcefully say that when you are silenced, in sense you are guilty. Nobody can prove me. Even the CRPC Article 161 talks about this, that if a person is silenced, even that is also not the thing, that the person will be treated as the person, as because the person is silenced, in sense the person is accepting the guilt. Until unless the person on his own mouth is accepting the guilt, the person is, I think the person is not guilty, the person is innocent. So this is what it says, that no man, even the accused himself, can be compelled to answer any question which may tend to prove him guilty of a crime he has been accused of. So this is the way it works on. So if a confession, even that's what I told you, even in, if a confession from the accused is derived from any physical or moral compulsion, it's like in hypnotic state of mind, it should stand to be rejected by the court. So the right against forced self-incrimination, it is widely known as right to silence. So if for example, a person is silenced, the person cannot be given a third degree, torture, and the person will have, if the person is bound to do that, that cannot be the scenario. The person cannot be bound to say certain kind of things. And I think even in Arushi Talwar case, these sort of things were actually done. I think if you go to the case or if you see the movie entirely, you will get a scenario that how the narcoanalysis test was taken and it was not admissible in the court of law, and that is why the parents are still behind the bars. So this is the way that the narcoanalysis test should not be forcefully done, should not be done in such a way that the person is silenced. The person have to be given a third degree torture, and the person has to speak, nothing to do. The person have to speak the truth, so that even sometimes I think the police says that you have to speak the truth, otherwise you will be hanged till death, or some or the other, some kind of torture or some kind of threatening is going on inside the prison. So these kind of things should not be taken into consideration. And if somebody is going with that silence or with that thing going against the principle of the article 20 clause 3, then that is violative, and nobody can go against forced self incrimination, because Constitution of India says that no person should not be the witness against himself. But if a person if a person is forcefully going, so then that is violative. But if a person willfully goes, so then that is not violative. So this is the thing that the person should understand while going through any kind of narco analysis test, whatever it may be, whatever the case it may be. So even section 161 subsection 2 of the CRPC says that it's bound to answer truthfully all the questions put to him by a police officer, other than the questions to answer to which there is a tendency that it can charge or penalty or forfeiture. So arguments made that narco analysis constitutes definitely mental torture, and thus it violates the right to life under Article 21, as it deals with right to privacy. So basically, if I am silenced, nobody can force me to speak up, nobody can torture me for that to speak up. So this is against my right to life, this is against my right to privacy, which is embedded in Article 21. So again, law against intrusion in privacy of individual would not allow brain fingerprinting evidence to be given in court. So we will be definitely looking into the other test as well. Narco analysis, other tests are also lie detecting test, and even we will even go for brain mapping test as well. We'll see what are the tests and how it goes on. Definitely we'll look into this. As of now, I'm just looking into the perspective which has been given by the legal or the law provisions, that what it is and how it is going against the law. If a thing is going against the law, then it will not be admissible in the court. So it is well established that the right to silence, even if you see the case of Nalini Satpathy versus PLD Ani, if you see this case, even in this case also it states that the course of interrogation, whenever the investigation is going on, nobody can forcefully extract the statement. So if a person wishes to keep silence, the person can do so. The person will not be tortured, or the person will not be threatened for that. So section 161 subsection 2 of the CRPC legitimizing the right to silence, and in this case it says that tests like narco analysis are not considered reliable, even because these kind of things are not 100% accurate. If you see, when I was talking about the drawbacks, I stated that in the drawbacks also the test you cannot rely 100% that the test is totally correct. So even studies in medical association in United States also states that it may be sometimes the serum or the drugs that has been given, it is not totally giving the truth. Sometimes it's misleading the answers as well, because the questions that has been continuously asked, the person cannot come up, or many times it is actually health dangerous. It is sometimes dangerous to the health as well. So if you see in this Townsend versus Sane, this is a case in USA. It was held that the petitioner's confession was constitutionally inadmissible because it was adduced by the police questioning during a period when the petitioner's will was overborne by a drug having the property of a truth serum. So in this case also, the police officer actually did not say that the petitioner's will was not taken into consideration, but the drug also was having a truth serum. So these sort of things cannot be taken into consideration by the court, because the confession was not taken by the will of the person, and definitely there was a truth serum, because if you see in this that adhere to the view that truth serums do not induce truthful statements. So it's not that every time that the drug that has been given, the drug will definitely give 100% result. So even in anything, we cannot say, even science also does not say that it's 100% correct. Even science also say there is some power, please pray for God or something. Science will do science cannot take that 100% guarantee that this sort of things will be 100% cure, because it actually never know, you never know how it actually will react person to person. Even if you see medicines also, if somebody is taking one medicine, that same medicine cannot be applied to another person's body, because our body is not same. Our systems are sometimes like generate differently. So maybe for that, the truth serum cannot sometimes give truthful statements. So this, it is subject to the condition of trance under the truth serum, and sometimes it may give false and misleading answers as well. So how is it as admissible in the court of law? So while it is like, there are certain questions, there are many critics as well, there are many criticisms as well, that is it a boon or is it a ban? Is it how there are doubts whether the testimonial compulsion is taken or not? Testimonial, let me tell you, the testimonial means the test of the character, any kind of quality that a person is having. So whether that testimonial compulsion is actually taken into consideration, whether there are actually many doubts which has been raised, that whether it is like violating the human rights, or whether there are individual liberties it violating, or the freedom of any person, whether it's violating those things or not. Lawyers also have divided themselves on whether the narco analysis of P300 test. Let me tell you, P300 test is brain mapping test. We look into this, that what is brain mapping test. Just after completing the legal background, I'll just tell you what is lie detecting test, and as well as brain mapping test as well. So that P300 test is the brain mapping test through the brain, how the answers come up. So that is another test. So I'll even show you the pictures where the brain mapping test goes on. So P300 tests are admissible as evidence or not. So it is actually semi-conscious person, the confession that is given by a semi-conscious person, whether it is admissible or not. So narco analysis test report have validity, but is not totally admissible in the court of law, which considers that it has been, so the circumstances to which it is obtained, like the circumstances needs to be administered. Basically, the accessibility of the circumstance. For example, the person is shouting, the person is saying, I will not go for polygraph test, I will not go for lie detecting test, or etc., whatever the test are brain mapping. If the person denies, or if the person is not in a mood, then the person should not be forced, or the person should not be harmfully or threatening by that if you say, if you do this, or the person without knowing the person is giving that kind of drugs to just see that what is the truth or not. These kind of things, the circumstances, if the circumstances so that the court is totally satisfied that the circumstances through which it has been accessed is totally can be taken or not, that depends upon the judiciary, that whether it is admissible or not. So the circumstances is very much necessary. So the results that of such test can be used to get admissible evidence, definitely can be collaborated with the other evidence to support the other evidence. So specifically investigation says, so the person is not on his own mouth, on her own mouth, the person is not saying the truth, or the person is not committing that yes, I have done that. If that is the thing, then these kind of tests, if the person is giving his or her consent, then these kind of tests can be attached to that, or adhered to, or adduced with the other evidence of the investigation. But if the result of this test is not admitted in the court, it cannot be used to support any other evidence obtained in the course of that particular investigation. So even the Central Bureau of Investigation, CBI also comes up with the permission of the court to get certain kind of test. So even I think in this Sushant Singh Rajput case also, I think many of them have seen in the news channels is showing that Riya Chakravarti to go for a polygraph test, but where Riya Chakravarti has denied that she will not go. So in that, no compulsion can be taken. So these kind of things shall be taken into consideration, where Riya Chakravarti denied that she will not go for polygraph test. So if a person totally denies, or the person is not willing to do, the person will not be forced to come into that thing. So in India, narco analysis was first used in 2002 in the Godra Karnaj case. So it is a famous case. It also came in the news as Arun Bhatt kidnapping case in Gujarat, where like National Human Rights Commission also appeared, and Supreme Court of India against the undergoing narco analysis. And it was again in the case of Telgi stamp paper scam. I have shown you the picture. This was the case in, when Abdul Karim Telgi was taken to test in 2003 December. So through those, in this cases, Telgi, immense amount of information was yielded, but doubts were raised about its value of the evidence. So in the first case in India, as you can see, Godra Karnaj case was the first case in India where this thing was actually taken place, but how much is it 100% accurate or not, still doubts are raised. But in the year 2010, Srimati Selvi and others versus State of Karnataka. In the year 2010, you can see May 10, 2010, the Supreme Court judgment on involuntary DDTs. One more thing, let me tell you, this narco analysis test is also known as the deception detection test. It is also known, the other name of narco analysis test is also known as DTT, so which is involuntarily taken. So where it's like continuously stating as deception detection test, so something which is deceptively taken. So DTT has no place in the judicial process. On the contrary, it will disrupt the proceedings and definitely will cause delays and complications in the result, and definitely this will delay the justice system as well. So results obtained by such tests bear a testimonial character, and thus they cannot be admitted in evidence if they have obtained through the use of compulsion. So the Supreme Court was very clearly stating in 2010 that if these things are bearing any kind of testimonial character and it is obtained through the use of compulsion and definitely again and again involuntary thing, then there is no place of this particular test in the Supreme Court, and it will not be taken, it will not be admissible as well. So the other methods of the other methods even in India, as is polygraph test, methods of lie detection is polygraph test and well as brain wave or fingerprinting. So as you can see, the polygraph test, which in the right hand side of the picture, it's quoting how polygraph test is going on, and on your left hand side is the brain wave fingerprinting. So just quickly let me tell you what is polygraph. So this is also a lie detector test, but this term is misnomer actually. That is why it's a polygraph test, and the theory behind this test is that basically the crime, the relevant facts of the crime, if a person is lying, then it comes up. So it produces hyper arousal state, and person is trained reading the polygraph results. So the before going into this, a number of parameters are also checked up, like the heart rate, the blood pressure, the respiratory rate, skin conductance, and electromyography. So all these things are also taken care of while going into the polygraph test. So there are certain principles behind these tests. So what are the principles? Because the principles needs to be checked up, because many a times the principle behind these tests are questionable, because the changes of the arousal state, sometimes the arousal changes can from 10% to 20%. So that is the thing which is actually questioned here. So unnecessarily not triggered by lying or deception. Instead, these would be triggering the nervousness, fear, anxiety, confusion. So all these things, as you can see, are actually, in alcohol or other emotions, all these things are the withdrawal states. So these kind of things should be taken into account, that these are the things which are actually questionable. So this state has also been attributed by the way of questions which are asked by the investigating officers. So it is not difficult to beat polygraph test by a trained person. Definitely a trained person can go for this, who is able to control or suppress the arousal systems by relaxing the particular patient or the particular person who is going through this, or the particular accused person. So this can be done through yoga, mediation, etc. So the reliability of the polygraph test has been repeatedly questioned in the empirical studies. So if a person is going for research, if you go for researches, it is questionable, because who is the person who is trained, how much the person is trained, and how much will be the arousal state. If the arousal state changes from 10%, 20%, so definitely that will be questioned. So these are the questions which are actually questionable and which is triggering. Now I come to the brain mapping test. Now brain mapping test is also known as the P300 wave test because it is known as brain electrical activation profile test. Okay, so in India it is known as brain electrical activation profile test. So it measures the changes of the electrical field potentials produced in the sum of neuronal activities in the brain. So for example, if something comes up in our eyes, automatically our eyes will close. Because of what? Because of the nervous system. Suddenly our nervous system will click to our brain and our brain will tell us that close your eyes because the thing is going through our eyes. Suddenly we'll close our eyes. If a finger like this goes, automatically our eyes will blink. Why? Because of the nervous system. So this is what our nervous system and our entire body is linked up. So it measures, the brain mapping is actually measuring the electrodes of the surface of the skin that is actually covering the head and the face. So the changes directly related to the specific perceptual or cognitive events such as event related potential. So definitely the event that is going on and our brain is something. For example, I think many of them has evidence this as well, that if we are thinking about a certain thing continuously, on the same night we'll dream, maybe sometimes we dream about that thing as well. Why? Because the event that is related to that potentials, we definitely try to dream about that as well. Maybe some of the murder cases or something we have seen in the TV and we are thinking about that continuously. Whenever we will be sleeping and we will be very tired, definitely at that point of time we'll see some kind of dreams related to that particular potential. So that is why brain mapping test is also essential, where the truth can come up. In simple words, it is finding the brain generates a unique brainwave pattern when a person encounters a familiar stimulus commonly used in India, which is known as brain electrical activation profile test. So it's simple sense, I would say that it is the person's, whenever the stimulus or the common method which is going into our brain, so that is the thing which are the wave patterns or the things which is going in our brain, the wave that is counting, and through it this particular brain mapping the thing come up. So this is a difference. If it is visible, it's good. But let me tell you, there's a difference that I have stated in narcoanalysis, polygraph, and brain mapping. So narcoanalysis is used in interrogating while measuring physiological changes. And narcoanalysis, drug-induced method. So which we have discussed, a drug will be induced. And polygraph, it's interrogating. So you need to interrogate. So there will be a machine. If you see the picture. If you see the picture, the person is sitting, definitely there will be no drug. The person will be giving, and the blood pressure and all these things. Sometimes a person can come into an arousal state. The person can be hyper into saying that particular questions or the answers that will be asked to him or her. So this is the way, this is interrogation where no drug will be given. And on the other hand, narcoanalysis, drug will be induced, and brain mapping, non-intrusive in nature. So it's not obstructive or obtrusive in nature, I would say. So next is in polygraph, interrogating with standardized questionnaires, definitely something which is again testimonial character. Those things will not be asked. Definitely related to the crime will be asked. Next is narcoanalysis, where medical intrusion is needed. Definitely medical intrusion where drug is needed. So medical intrusion definitely is needed. Brain mapping, brain waves, graphs, computer to analyze. So in this brain mapping, the brain waves, how it is going, that should be analyzed. Thereafter, in polygraph, the BP, pulse, EG, GS, GSR, which all these things will be analyzed. In sense, the blood pressure, the EEG, the pulse rate, then blood pressure, then all these things will be analyzed in the polygraph test. In narcoanalysis, subject made to speak in trance. So definitely when a person is with that semi-conscious mind, how much the person is transfully speaking. In brain mapping, confirms the specific information available in brain. So whatever the information is available through the brain, that comes up. Next is in polygraph, physiological changes of involuntary process is measured. So how much the physiological changes are there, what is the involuntary processes are the person is not actually who don't want to say, so that should be measured. In narco analysis, the age, sex, health of the subject determines the drug dose. So the drug should be given, determining the age. If the person is minor, then that drug. If the person is adult, then the specific drug. In that, it should be determining the drug dosage should be determined. In the brain mapping, it does not confirm about the information stored in the brain. So sometimes it does not confirm of the how much information is stored, so it does not actually determine. So all these things should be determined and should be taken care of. And the last thing is that how much reliability. So polygraph test is least reliable in deception detection, whereas narco analysis is more reliable, and brain mapping is the most reliable one. So I think now it's clear to all that this is the way it goes on, that these are the other two ways. So polygraph is the least reliable one, narco one is the more one, and brain mapping is the most reliable one. So I think it's like just the degree of comparison. So least one is the polygraph, narco analysis is the more reliable, and brain mapping is the most reliable one. So by this, I think it's clear to everybody that what is the way the person should go on. And again, the person should be informed about these kind of tests. So in India, the narco analysis test is done by a team. So who and all will be there? So again, I'm coming back to narco analysis because my topic actually concerns about the narco analysis. So I'll just stick about this. So in India, narco analysis test is done by a team. So the team can be anesthesiologist, psychiatrist, a clinical or forensic psychiatrist can be there, an audio videographer who will definitely audio, and this is very important because with the audio and videographer you cannot prove it, and there will be supporting nursing staff as well who will be supporting that. So the forensic psychologist will prepare the report about the revelations, which will be accompanied by a compact disc of audio-video recordings, and the strength of revelations, if necessary, will be verified. And the person to polygraph and brain mapping test also the same thing is done. So the same way, even in polygraph and brain mapping test are also done. So lie detection test comes under the general power of investigation and under section 160 to 167 as well of the CRPC. So like it is given to the police officer, like even to the CBI, the police officer does not go through, then the CBI can go for these kind of investigation. While criminal investigation, these kind of things can be done, but again with the permission or with the consent. But it must be realized that it is a prerogative of the person to allow himself or herself to put into that kind of test. So it should not be left to the discretion of the police, because otherwise this will be illegal and unconstitutional. So it should be definitely the person should know about it, because without free consent is something, I think in the Contract Act also we say that free consent should be given, something which should not be against fraud, misrepresentation, undue influence, mistake of facts, mistake of law. So I think if a person says that I wish to take a lie detector test because I wish to clear my name, if it is so, then definitely that voluntariness will be taken into consideration. That circumstances or that voluntariness is not under any coercive or under any undue influence or not, that needs to be taken. So that it's to be actually considered. So it shows the voluntariness, but it is still to be shown that whether that voluntariness was under any coercive circumstances or not. So such kind of voluntariness sometimes also can be given a gun in the head and saying that you have to say that or you have to do it. If it is so, then that will not be considered. So again, there is a lot of questions again which will be coming into these kind of things, and how it will on how it is proved that what is the circumstances or not. So that is a very much debatable issue actually. If a person is told by police, if you want to clear your name, take a lie detector test or take a lie detector test. If something like these things is stated by the police, then that will not be the circumstances. The circumstances should come from the person who is who has been accused. That person will say that yes, I want to. If this is so, then only that circumstances will be taken into consideration. So three things cannot be long hidden. I think all will clearly say yes to this: the sun, the moon, and the truth. Now that is a huge question, that how much truth is actually really taken into consideration and how much is actually revealed. So truth alone triumphs. I think everybody will understand and everybody will definitely support this. Even our Constitution of India also says about this. Even India also support this truth. Like truth is something which should actually prevail over anything. So let me go into the things which actually I was about to do, but I said I will be first doing about the thing of the Indian Constitution, the law, and thereafter I'll come to the criticisms, and thereafter I will just conclude my topic. So the drawbacks which we have already stated, now I just go into the criticisms. Now I'll speak on two. So whether it's a boon or whether it's a ban, two things I'll say here. So first I'll go into the boon. First I'll say into the ban one, and thereafter I'll go into the boon one. So the criticisms of the narcoanalysis test, like it is criticized on the ground that is not 100% accurate. So it's subject to totally sometimes false statements. It has been found that it has been made totally on false statements. It is often unsuccessful in eliciting truth, as it should not be used to compare the statement already given to the police before use of the drugs. So there is a contradiction of that particular statement. Sometimes before the drug the person is saying something, after the drug in the subconscious mind the person is saying something. So you should not compare that the statement already given to the police and before using of the drug. So it is often unsuccessful in eliciting that particular truth. So it is like it is found that a person who has been given that kind of false information even after using the drug, so it is not much of help. So it is very difficult also to suggest which kind of correct dose of drug to a particular person, because of age, sex, all these things will be necessarily stated. So sometimes it's also difficult also that what drug, because you never know that the truth serum which has been used is actually reacting how much to what kind of person. That's what in the previous thing also I said, that we are all human beings, but we are not same. Our body may be reacting, the reaction should not be same. Every person's reaction is not same. The wavelength of every person is not same. Like if I'm teaching in a class, for example, maybe the wavelength of the students are also not similar. One student can catch hold of it very quickly, another student cannot catch hold of it. So the wavelength of the brain is also not similar. So how can the dosage be similar? So that is why it's very difficult actually. So even that is why successful narcoanalysis does not depend on injection. For its success, a competent and skilled interviewer is actually required. Now, like who is that particular skilled one who will actually do that kind of things? That is a question here. So narcoanalysis test is a restoration of the memory which the suspect had forgotten. This test actually may be doubtful because of the confession of the crimes. And even narcoanalysis test is not even recommended as an aid to criminal investigation. Even in medical uses also, it may be useful to medical uses like treatment of any psychiatric disorder, these kind of things. But to suspect or to go in a criminal investigation, unless the test is taken with consent, that kind of thing is illegal, and it will not be taken into consideration. So this is all about the ban one, a person criticizing the narcoanalysis test on the ground. Now, if a person is saying that narcoanalysis test should be taken into consideration, the other view of the legal validity of narcoanalysis test is that it is used as an aid for collecting evidence and helps in investigation, and does not amount to testimonial compulsion. So if a person is giving consent, then what's the harm in going in that? You can go, but there should not be any kind of compulsion of testimonial compulsion. Means any character or any objective, there should not be any kind of compulsion in that. If a person is willing, on the circumstances is such that the person has willingly said that yes, I want to go, then that thing should be taken into consideration. So thus it does not violate the constitutional provision regarding the protection against self-incrimination, because self-incrimination says that the person, but nowhere it's written that the person willfully is coming, then it is violating. So supporters of narcoanalysis test are of the view that narcoanalysis is particularly useful when there is a requirement of required information for preventing any offense by terrorists. Even I think in CONCEPT case also, I told you in CONCEPT case also, this narcoanalysis test was taken. To actually, that terrorist was the only terrorist through which the thing was taken into consideration, and he was hanged till death. So these kind of things are actually helpful even. So however, its application must be assessed objectively so that it can be replaced by existing conventional method of interrogation, which brought shame, ignominy, and disrepute to police, leading to erosion of credibility of criminal justice system. Definitely, these kind of tests even helps the traditional kind or conventional kind of interrogation, because where criminal justice system is also questioned. So narcoanalysis tests can even be effective. It is an alternative to the barbaric third degree methods. So continuously I'm going through the third degree method by the police officer. It's better to go for narcotic test and saying that I am not guilty. So that is a way. It is also, this is a way a person is also not tortured anymore behind the prisons. Care, however, must be taken. This procedure is not misused. So these kind of procedures, see, as I told you, how internet is very much valuable to us. Now through this internet, we are accessible. I am in one part. Many participants here can see me, but there are even risk as well. So here, even narcotic test, which is scientifically, again, it is not 100% proven, but there are risks which is attached to it. So that thing should be taken care of. If that is taken care of, rest of the things I think should be taken into consideration. So in the case of Dinesh Dalmia versus State of Madras also, like there was the thing which was conducted, and scientifically it was conducted by conducting polygraphy. So narcoanalysis and brain mapping test on the accused to bring out the truth will not amounting to breaking of his silence by force. The irony of the modern law jurisprudence is that there are many learned counsels engaged to defend the rights of the accused, while there is none to defend the public cause and interest. That is so true. So what is the thing about the public cause and public interest? Is there anybody to defend about that? Everybody is defending the rights of the accused. Anybody defending the rights of the public cause and interest? How much? There are so many publics. There are so many public who are affected by that particular incident. Is there any law for that? Is there anybody fighting for that? There are so many things we are talking about the accused. So these are the things, these are the bone of this particular thing. What in supporter of the narcoanalysis test have, as because this particular topic is a very debatable topic. So that's why I have put the things here. So in Krushi and Charminar bank scam evidence, thousands of depositors lost their lifetime earnings and savings meant for education, the kith and kin, to perform the marriage of the children, pensioners, benefits, see, all these things. What happened? It brought suicide. Many people lost their lives. Yet, when the MD of Krushi Bank was nabbed, he refuses to go for narcoanalysis procedures. What happened? Nothing happened. Anything happened? No. So this is the way that in such instances that the right against self-incrimination is upheld against the public interest, and it would weaken the evidence and thereby denial of justice to the public. So murderers, money launderers, terrorists are allowed to walk away scot-free, exploiting the loopholes in the legal system. Ironically, in all these issues, we apply criminal procedures only to protect the individual freedom of the accused, while rights and lives of many people have been sacrificed. This is actually true. If you see, the present criminal justice system is obsessed with individual liberty and freedom. And in this context, the safe passage foregone and criminals due to weakness in the criminals due to weakness in the criminal justice system, leading to the dilution of the evidences. And thereafter, this narcoanalysis is upheld, and the thing should be taken into consideration, and the circumstances, whatever the circumstances the person is willing to, should be obtained, and so that the miscarriage of the justice should not be there. And with due all the precautions and all the care should be taken into consideration, and it should be upheld. So the provisions of the narcoanalysis test, where it is compulsory or for the accused in grave offences, will improve the quality of the justice system by strengthening the evidence system. So even I also think sometimes that whenever there is a grave offense, rarest of rare case, these sort of things, then these things should be taken into consideration and compulsorily made. Because if we see that it is violation of the fundamental rights, violation of the individual rights, individual freedom, then where does the public comes? Where does the people who are sacrificing their lives? What is the thing about them, if we talk about that? So this move will bring about a qualitative change in the criminal justice system, and definitely the death chambers of the police stations are replaced by operation theaters administering truth serum on the criminals, and thereby offering a ray of hope that justice at last will prevail. So basically the police stations will be replaced by operation theaters, definitely, and there should be truth serums, and at least not 100%, but at least 99% truth will prevail and justice will be given. So let me just quickly complete the today's topic by going into the conclusion of this thing, where I have stated all these things in behalf or in, because it's a debatable thing. So where on boon or a ban, both the things I have completed, both the things I have said in front of you. So law is a living process, dynamic process. Even constitution is a living constitution. Constitution is also changing because the society is changing. Society changes, law changes, because the law is for the society at the end of the day, right? So it changes according to the changes in society, science, ethics, and so on. The legal system should imbibe developments, advances, and the science, so long as it does not violate. So we should keep in mind the laws as well, which is there, should not violate that, but it should change according to the changes in the society. So India most probably uses the narcoanalysis, but it is hugely debatable. So our Indian legal system, our society is something which will be clearer in the near future, which I believe it's actually somewhere or the other it's hazy, because it says about the circumstances, it says about the consent, it says about the offenses, it says about that there should be protection of the persons who are being the accused. There are even protection of the public in general. Right to life is not for the accused, it's for everybody. So there have been orders for various high courts about the validity of the narcoanalysis. Even on the contrast, the Article 20 Clause 3, the veracity of this even is talking about this. Even there are many judgments which we have seen earlier, which are in contrast with the judgment of the Article 20 Clause 3, because it's saying that the central government makes a clear policy that the narcoanalysis is at stake in India's commitment to individual freedom and a clean criminal justice system. So something should be not doubtful or unreliable, because now narcoanalysis is gaining judicial acceptance and supports despite being unreliable and doubtful. But there are these circumstances again which needs to be proved. So serious thoughts should be given about its legal constitutionality from human rights perspective. So I think from the human rights perspective, some kind of a thing should have been taken care of. People should actually think about that, what will be, that in which way it should be taken into consideration, in what way it should be admissible in the court. So this is the way that I thank you everyone by completing my entire project. And I would obviously say my moderator, that is Manav, thank you. Even Anand as well, who has given me this platform to speak up, and all the participants here who have patiently heard about the narcoanalysis and all the tests that is going on. And I would like now to take up, if there is any questions which is there, I would definitely like to take up. And thank you everybody for listening to this particular session for today. Thank you.
So, thank you, ma'am, for a very enriching session. So, ma'am, with your permission, like we have some around 35 questions, so we'll be taking
Right.
few of them.
Yeah,
So,
yeah,
ma'am,
sure.
first question is from Shanawaz Shanuddin. He says
Mhm.
that whether narcoanalysis test violates Article 21 of the Constitution of India.
Violates Article 21 of the Constitution. Yeah, definitely. If you see in the one way, that's why I told you it's a debatable issue. So one view is saying definitely is violating the right to life because the accused. If you see in the perspective of an accused, see, I'll tell you two things. In the perspective of an accused, if you see, it is violating. If you see in the perspective of a person who is affected from that particular crime, then it's violating that particular right of the person who actually needs the justice. So if you say Article 20 on the very perspective, if the person is without consent has been taken, then it's definitely against the right to life, but with consent, with the circumstances, not against the right to life.
Next question is from advocate Pinky Kapoor. She is the practicing advocate at Delhi High Court. She says that, ma'am, whether what is the nature of a statement given in narco test and whether narco analysis test is legal at a country,
Legal at a narco analysis test is legal
legal at a country.
at our country. Okay, the narco test is valid to that extent if the person has been consented and given his or her information. So consent is very essential. If a person is giving his or her consent, now one more thing, consent should be taken in a circumstantial way. Now, for example, if the police say in the lockup that if you go for a narco test, then only you will be released, you will be proving guilty free, you can be scot free. If this is so, then the circumstances is such that the police has bounded that person. If the person comes up with his or her own consent stating that yes, I want to go so that I want to clean up my name, then that particular thing is valid. So you need to see that with circumstances. So it's very questionable. So all these steps as actually whenever if you see that all these steps are coming, then only the Supreme Court will take it. Otherwise, Supreme Court will reject it. So this is the way it goes on. So it's a huge debatable issue, I would say. Advocate Pinky.
Ma'am, next question is from Shistika Bhattacharya. She says
Okay.
that if suppose if offender is made to do this thing, then what? No, no, what question? Like she is not from the frame the question properly. Like she is trying to say that if forcefully offender is made to do this thing, then what action is taken by law? Like a narco test.
Yeah, if a narco test, definitely also, nothing can be forcefully taken. Not even a narco test. If you say narco test is just a topic for today. That's why I'm telling you. Nothing should be going against the will. See, if a person don't want to do anything, I don't think so. Nowadays, there are so many laws that if you don't want to do anything against and anything which is done against your will, there are so many laws. But if you are concentrating on narco test only, then where I said that it is against Article 20, Clause 3, it is against Article 160, Section 161, Clause 2 of the CRPC. So if these are the things which are going on, then definitely the person will be, that thing will not be taken into account and the person will be scot-free. That is the thing. The person cannot be behind the bars. The person will be scot-free. The person will be released. The person cannot be behind the bars so many long time. And if there is a there is forcefully done or something has been forcefully done, then the opposite hand, the police officer will be questioned and his or her job will be at stake. So these are the things are taken care of. Even if you see Talwar case, Arushi Talwar case, what happened in this case? There was a CBI, two CBI were actually there. The first CBI which was stating that it was the driver of the Anushi's father who had done so. So next CBI which stated that no, it's the father and mother only have done. Why it is so? Because the narco analysis was taken without the information, without the consent of them. So that is why you cannot go against without anybody's consent. Consent is a thing which should be taken. Yes.
Ma'am, one question is from Prashant Tripathi, advocate. I'm very.
Yeah, I can see how much has narco
Yes.
facilities developed in India. Yeah, in India again. First of all, the cases which we have seen from Kasab case or Arushi Talwar case or from Telgi scam case, that time there was it was not a clear picture. Now, at least Supreme Court, after the Selvi case in the year 2010, it was very clearly stated that if anything which is against the compulsion, I mean, which is taken against the will or which is involuntarily taken, or anything in narcoanalysis test, anything which is taken with compulsion, then that is not admissible in the court of law. But anything which is taken willingly, if a person comes on willingly, then that is taken into consideration. So I would like to state the recent case of Sushant Singh Rajput. Even I've said also while presenting the this narco analysis, but Riya Chakravarti was about to go for polygraph test. I think media also plays a very important role here. So where media also was saying that Riya Chakravarti in the headlines, Riya Chakravarti will be going for a polygraph test, but Riya Chakravarti shouted and said, "I will not go for that." So this is the way our India stands. That if anybody is not willing, so the person cannot be forcefully taken into that. So this is how our India still now is going into this. We cannot force anybody.
Ma'am, there is one big question from Siddharth Addy. He says that methods like use of alcohol for extracting information is admissible in court of law, but scientific methods like brain mapping and narcoanalysis are not. Why is it so?
Okay, this is a very good question, I would say, for that. Okay, let me tell you one thing. If somebody is alcoholic and that particular thing is not taken, and scientific thing you are saying, but I would say sometimes a person who is going into alcoholic and giving statement because the person has taken the alcohol on his or her own will, and the person is not in compulsion coming and in taking that alcohol. This is one. Second is drug, which is very effective. How it is affecting, you never know. So that is why the scientific test is a bit risky, going through the going for that drug or the thing what you said just now, that if a person is alcoholic. This is one. Second is, this is the thing which I will be against it. Now, if you say for in our country, criminal system or justice system is something in a democratic country like India, I would say justice system is some where tariq pe tariq comes up, and thereafter the justice comes. So justice is not so an easy thing or easily comes. So narcoanalysis test, that is why it takes a long thing, and compulsion obviously will not be taken into account. So here with but for my view, if you ask, definitely if a person goes for a heinous crime, and it has been proved that there is a heinous crime where the police officers are also not able to justify, then I think that this should be taken into consideration and it should be made compulsory. That narcoanalysis test should be made compulsory. I think so. This is my own view, if you say, Siddharth.
Ma'am, there is one question from Hardik Verma. He asks, "Ma'am, I have one question. Doesn't narcoanalysis infringe our right to privacy?"
Yes. Again, on the side of the accused, definitely right to privacy is hampered. But if you go against the side of us, public interest, then I think, again, if it is a grave, heinous crime, definitely, then I think that should be made compulsion. I think so. So yes, right to privacy is hampered because if you are going against the will of the person and saying that you have to go, then that is why the privacy of that person who is like don't want to speak up, or the person wants to keep silence, you are going against that will of the person and going for that kind of test, then it is against the right of privacy.
Ma'am, there's a question from Devarjun Day. He says that whether police require any consent of the criminal for polygraph test, or it is done without any consent.
No, definitely consent is required. Without consent, the police cannot go. So there is a consent which the police obviously should require it. because these are the things the police cannot do. So there are so many persons who are involved in it, the medical people. There are like, you know, a nurse who will be there, supporting nurse will be there, doctor will be there, psychiatric will be there. So without these, suddenly the police cannot go for. Consent will definitely be taken, but there are procedures by which you can go for. CRPC talks about it. But again, consent will be taken by the police officer, and even the CBI also. If the CBI also want to go for it, even they also needs the consent of it, and definitely the consent of the accused person.
Argho Karmakar says that whether there is any need of appropriate legal provision to imply narco tests for serious offences against humanity and against the state.
There is no
humanity and against the state.
Yeah, so that's what I said, that there is no such kind of things which has been taken care of. So there is no clear picture. So from my side, I want to say, even in the PowerPoint also I've said that yes, that should be made a compulsion, I think, so that whenever a person has gone for a grave heinous crimes, I think that kind of thing the Supreme Court should make it very compulsory, that like narcoanalysis test should be made compulsion for that. So that, you know, there are so many third degree torture which is going, you never know, which actually is going throughout. So these kind of things should be stopped, at least. Then it will be easier also for the police people or for us also to see that yes, this person is the criminal person. Because, you know, in news also every day we are seeing Riya Chakravarti is going for this and that. So I don't think so that when the people all are getting the thing, then when the truth will come. So in these kind of cases, I think things should be made compulsory. I think so.
And one last question from Hardik. He says that as I know, right to remain silent is a fundamental right. So, ma'am, how narcoanalysis is a legal way to identify the truth?
Okay, this is a more or less same question only. Okay, right to silence is definitely a fundamental right. Nobody can force me. Whatever I want to say, I can say, and nobody can even torture me for that. Police officer cannot torture me. So now, narcoanalysis test says that if a person wants to say or remain silent, narcoanalysis test cannot be taken even on that very ground as well. If an accused is keeping or remaining silent, narcoanalysis test cannot be taken on that very person, because a person consent is very needed. Now the laws are also silence in it. Laws are not there for narcoanalysis test. Where the narcoanalysis, and one more thing, narcoanalysis test, there is no separate laws for it. One of the thing which is a very much thing which is actually required, that a separate law should be there, that in which of the crime the narcoanalysis test should be taken and which of the crime should not be. So I think narcoanalysis test should make it should actually be made compulsory for that grievous comment. But yes, not for those crimes which are easily provable or which are easily the police officer should go for investigation and find it out. Otherwise, if it is compulsory for all the cases or made compulsory for all the cases, then the police officer, it will be very easier for the police officer. The police officer, all the people will go for narcoanalysis, and again, it will be health risky also. So I think, keeping in all these things in mind, we should make a separate law for that. It should only be made compulsory for those cases which are heinous and grievous in nature, and where truth is actually not, it is not visible to anybody. In that cases only, rarest of rare case, I would say, then only the thing should be compulsory. That's it.
Ma'am, there was one more question is there by Prashant Tripathi, is there in the private chat. So he says that kindly clear the concept of what sort or degree of consent is required so as to obtain a narco test.
Okay, what sort of degree of consent? Now that is the question actually. Now, if a person has been, again, this was clear enough, but again, for you, Prashant, I'm telling you that the consent should be taken with free consent. I think we have heard about this free consent several times in Contract Act also. Free consent means same thing in the same way. So if I'm saying you that, do you think that today's session was good? If you say that yes, so in sense, You are also thinking today's session means today's session. It's not yesterday's session. So it means that whatever I am telling you, you are also thinking in that same thing. Same thing in the same way, same manner, or same sense rather. So it's something which is free consent. There should not be any kind of degree of compulsion, any kind of threatening, any kind of lucrative orders that if you say I will give you 1 lakh rupees, so these kind of things should not be there. These kind of things should be avoided. So I think the basic things I would say it should be a free consent. I think the word free talks about everything. Free means which should be irrespective of fraud. It should not be of like any kind of consent taken in fraud or misrepresentation, mistake of fact, mistake of law, undue influence, coercion. All these things are there, right? In free consent, I think all contract laws are coming into my mind. So these are the things of like consent, degrees of consent a person should be taken, and then only it should be admissible, otherwise not.
Ma'am, Devina Mitra has just typed a question. She says that, ma'am, in case of a mentally retarded person, if he has no guardian, then whose consent will be taken in such cases?
If okay, this is a very good question. If a person who is disabled, so definitely he or she don't. There are two kinds of disability. One is person who is understanding, then definitely the person himself. Another person who is not understanding and not having a guardian, then definitely the representative. If he or she is having a representative, no guardian, then a representative. If he or she is not having a representative, then definitely the doctors can give a consent of that. The doctors can definitely give the consent, because the doctor will take the consent, or the doctor will give the consent on taking the total responsibility on him or her. I mean, the doctor will take the responsibility that if anything happens, then he or she will be responsible thoroughly. Because mentally retarded person reads a very much, the person should be cautious and a lot of care should be taken while taking up these kind of tests. So the doctors will take in these cases, basically the doctors will take, because the doctor will understand that how far the patient will react to this. So definitely doctors will take into consideration for that.
Okay, so finally we come to an end to this third webinar series organized by LawyerGenics. So once again, thank you so much, ma'am, for taking out your lovely time. And once again, we had a really great session. So guys, like before LawyerGenics, ma'am had also conducted a webinar on section 377, whether the Transgender Act is basically benefiting the transgenders or not. You can watch it at Immortal India's YouTube page for more information. So officially we come to an end to today's webinar on narcoanalysis, and all the PPT and everything material will be shared to you by our team through the email IDs provided by you all. So on behalf of me, Manav Soni, the marketing head at LawyerGenics, and Koyel ma'am, so take care, stay safe, and have a really great day ahead. And here we sign off for today. Thank you, ma'am, and thank you to all the viewers.
Thank you, everybody. And one more thing, Manav, whoever has question, there are a lot of questions. So if anybody wants to ask that question, please send me personally. I will definitely answer them. Okay.
So
There are lots of questions.
if
There
you
are
have
lots
any
of
questions, yes.
So if anybody
So-
wants to ask me, you can ask Manav. You can send those personally. I will definitely answer to those. Okay. Because there are many questions which it's not possible for me to actually take up. So like if you want to, I'll definitely answer those. Okay. Okay. Thank you.
So you all can send your questions if you have at our lawyer to Anand, like he'll be addressing it to ma'am personally. So we'll hereby sign off for today, and thank you all for being a part.
Thank you, everybody. Thank you.